The law matters. Of course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters, because the law matters. Have a better understanding of the law, and that makes you better prepared to protect yourself, your family, and your business. As we present various topics, you may decide that you want to handle some issues yourself. If you decide to enlist a professional, you'll be better prepared, and so will the professional you select. Our goal, as always, is to help you save time, money, and to achieve the best possible results. And also, as always, we welcome and thank Attorney David Bizarre from the Bizarre & Associates law firm in East Providence, as he helps us as we tackle various legal issues throughout these segments. Today, we'll discuss the abortion showdown. Alarms are certainly ringing. As of this taping, the Supreme Court agreed to hear the very contentious debate over abortion. Roe v. Wade was settled about a half a century ago, and it established the constitutional right to abortion. The new case that they're going to discuss concerns a Mississippi law that's seeking to ban abortions after 15 weeks of pregnancy, about 2 months earlier than the Roe and subsequent other decisions had allowed. So whether you're conservative or liberal, all see the acceptance of the Supreme Court seeing this case as pivotal. And as of today, Texas Governor Greg Abbott has also signed into law a bill that bans abortion starting 6 weeks out. So we're going to discuss the issues, the law, some of the perceived political and personal impact, and how it's going to affect your life. So David, why don't you set us up by talking just a little bit about that Roe v. Wade landmark case some time ago.
So the good thing is we can talk about this from a legal perspective. Nobody has to know what we think personally.
That's right.
So we can discuss it from the perspective of the law. And in doing that, I think the best way to understand Roe versus Wade is to understand the criticism of it that Ruth Bader Ginsburg had for Roe versus Wade. And it's interesting because when Ruth Bader Ginsburg was nominated to the Supreme Court, there was some concern amongst those people who were supportive of Roe versus Wade over a lecture she had given criticizing the case. And what she wanted them to know was that it was not the decision in the case that she had an issue with, it's the way they reached that decision. So in Roe versus Wade, the Supreme Court took the position that under the Constitution, there's a right to privacy, which is violated by the government telling somebody whether or not they could have an abortion. But in that case, I think it was Texas law that was being challenged, and the law had much stricter rules than some of these new laws that are coming out now. And there are those who said if the Supreme Court had stuck strictly to the law that was at hand, it wouldn't have been as landmark a case as it was or as controversial. What Ruth Bader Ginsburg wanted to do was she had another case right around the same time as Roe versus Wade. And it's interesting because Ruth Bader Ginsburg always took an approach to these kinds of cases that was sort of the mirror image to make a point. So if you remember the movie, I think it was called On the Basis of Sex, she took up a case about women's rights and equality, equal rights under the Constitution, and took a case for a man who was being disallowed taking a tax deduction because he was a man. If he had been a woman, he would have been allowed to take it. And so she's making the point that it's equal rights are equal rights, and you can't violate them for a man or for a woman. And that's how she wanted to start setting the precedent for these types of cases. So the case she brought was for a woman who was in the Air Force, and while she was in Vietnam had become pregnant, and the Air Force said that she either had to get an abortion or be discharged from the Air Force, whereas the partner in her getting pregnant had no consequence for the fact that she was pregnant. So Ruth Bader Ginsburg brought the case on the basis of a violation of her equal rights under the law that she was being discriminated against for being a woman, her right to make decisions for herself, and she was Roman Catholic, and it violated her religious rights to make her own choice. The case actually was dismissed or removed because the Air Force relented before the case came up for hearing in the Supreme Court, so it was never decided. But the point that Ruth Bader Ginsburg would have made and that the case would have stood for was that the right to an abortion should be an equal right, a woman's right to decide for herself, not on the basis of privacy, as was the decision in the Roe versus Wade case, but rather under the equal right protection on the basis of sex.
And that Roe v. Wade back in '73, it was in the Supreme Court, and ever since there have been many states having some issue that they wanted to bring to the Supreme Court. It's not been brought to it's not been brought as it is right now. So how did something like this finally get through from the state of Mississippi to the Supreme Court? How does that actually happen?
So there actually have been a number of cases that have been brought following Roe versus Wade.
Yes.
And there is a long-standing line of precedent as to what states can and cannot do, which would be considered whether it violates someone's constitutional rights. So the way a case gets to the Supreme Court is you bring it through the district federal court and then the Court of Appeals for that area, that district, and then you file what's called a writ of certiorari, which is a petition for an appeal to the Supreme Court that the court then has to look at and decide whether to take. And for a case to get accepted for a hearing in front of the Supreme Court, 4 out of the 9 justices have to agree that it's worthy of being heard, which is what happened in this case.
So in fact, that Mississippi case apparently a dozen times was submitted, and this time was accepted. So that has prompted the challenge, the question, why now? Many will say that this, as it's being challenged, is whether the states can ban that fetus based on the fetus existing outside of the womb, but it is not supposed to be a direct challenge to the constitutional right that women have that was announced set back in '73 and then reaffirmed, I don't know if it was 19 years later, but something close to that. But it is saying that there's a chance that the fact that they are taking it at all, it's weakening the protections of whatever they're calling pre-viability. Does this open the door as just by virtue of the fact that they're taking it? Does this give the states now more option, as we're starting to see? Is that actually happening, and is that legal?
So, in my opinion, as a lawyer, the long line of precedent that's still out there and hasn't been overturned by any Supreme Court decision still stands. And just by accepting a case for review doesn't change that. Nothing changes until they issue a decision on the case and lay something out that either supports everything that has been upheld by the Supreme Court and the lower courts to date, or changes it in some form or fashion.
And so now when we think about the most recent appointments, every single appointment that's come through has been asked, what is your position on? Some for, some against. Doesn't really matter right now, except now, because this case is coming to the Supreme Court, there is a different there's a different kind of balance. There's more weight on what they consider the conservative. Should that really matter in this situation if they're just evaluating the law?
It shouldn't, but that doesn't mean it won't. And it's been, interestingly enough, there have been a history of Supreme Court appointments where people look at their records, their history, what they seem to stand for and what they predict that they're going to do, and have been totally wrong. And so if a justice sits at the Supreme Court level and looks at the law and keeps their own personal feelings about what the law should be out of it, but does accept, people can have a different view of what the law is and what it should be. but you have to keep an open mind to the arguments that you hear and what a rational reading of the Constitution and the law is, and then apply the law to the facts. So if the justices who are sitting there that are new stick to that kind of interpretation of the law, you don't know what they're going to do until they hear the case. And that's why many times, and this again, I think they call the Ginsburg rule, when they're asked at a confirmation hearing, how would you rule on a case like this, or how would you rule on a case like that? Justice Ginsburg and many people who followed her would say, I'm not going to comment on a hypothetical case that could reach the Supreme Court or is pending before the Supreme Court, certainly, because I haven't heard all of the arguments, the facts, and everything else that needs to be applied to the case.
Good point. So while those on both sides will talk about, is this even constitutional, that who but the U.S. Supreme Court justices would know better what the Constitution is about. And yet it is challenged, depending on which side of the fence you're on. It wasn't in the Constitution. It was never written in the Constitution. Our framers did not have the word abortion in their language and had no such reason. They did, of course, have a whole lot of feeling, 10th Amendment, I guess, about states having some rights rather than the federal, rather than the national, the federal being able to have utter, complete control wielded over the states. So is it constitutional? Is this a constitutional issue again?
So if what you're saying is, should the Supreme Court have the right to review the constitutionality of a law passed by the state, because the states under the 10th Amendment have the right to pass laws and that type of thing? That's not exactly what that says. The 10th Amendment basically says that all rights or laws, whatever, not given to the people or to the federal government are reserved to the states, and they can make their own rules and so forth.
Yes.
There's also a clause in the Constitution called the Supremacy Clause that says that the Constitution is the supreme law of the land, and nobody can pass a law, states, cities, or towns, federal government, or otherwise, that violate the people's constitutional rights. The rights protected under the Constitution.
And yet, all the time, you hear about what is considered the original intent of the Constitution. Well, the Constitution was written with whatever intention, but when that language was not available to them, how can someone presuppose that they can go back and say, this is what was meant? And of course, that's what the debates are all the time. They didn't mean that. Right.
So different justices have different ideologies, if you will, or philosophies on how to interpret the Constitution, and do you have to go back to the original words? Do you have to go to the original intent, how it's written, what the purpose of the Constitution is? However it is that you want to look at what your frame is in interpreting the Constitution. But there are certain things that have always been in the law and that you have to follow, stare decisis, precedent, res judicata, all of those things that are things that go into how you interpret the law and the Constitution. And the one thing that's a constant is look at the words of the Constitution for what is protected and the decisions that are followed that. And that's the rationale that you have to apply in deciding whether or not a law violates the Constitution. What are the rights that are protected? Because remember, the Constitution and the Bill of Rights, the first 10 amendments, were designed to protect people from unreasonable governmental interference. And they were breaking away from England with a king at the top, and the king is never wrong. You have to follow whatever the king says. We didn't want to give too much power to one person, but we had the Articles of Confederation that weren't strong enough, so we wanted a stronger federal central government. We didn't want to take away the right of states to do certain things and have their own rules and how they do things. But it was the rights of the people that first and foremost had to be protected, the liberty rights. And in that case that I mentioned at the top with Ruth Bader Ginsburg, one of the arguments was a liberty right. You're interfering with a woman's liberty right to make her own decisions, and that is in the Constitution.
And yet, of course, the way you present it, it would almost seem that it would be a concluded case, point final, end of story, and yet all we're hearing now, well, we continue to hear that the states are lining up with their own versions of it's 6 weeks, it's 15 weeks, it's you have to make sure that there's counseling first, imposing what they think is the right thing that they think is the right interpretation of what this law is, and including Roe v. Wade isn't constitutional. So while each one of these states has a listing, South Carolina has one, 6 weeks, Kentucky, getting to close and penalize those who have abortion clinics. Arkansas has to have a state-supported hotline. That's saying that there's an awful lot of rights still from the states, regardless of whether or not there is a legal right to an abortion and a woman's right for her reproduction rights and make her own choices.
Right.
So these are going on, and there's a lengthy list: Ohio, Kentucky, and Kansas, and so many of these initiatives make it seem clear that it isn't that clear.
Well, there are some weighing and balancing issues between the liberty right, the equal protection right, the privacy right of Roe versus Wade, and all the other rights of a woman to make decisions versus the right of the unborn fetus. And so some of those laws that you're talking about are trying to pull back on some restrictions that have been put in place for late-term abortions when a fetus is viable, if it could live outside the womb, those types of things. So there is a weighing and balancing that I think that needs to take place in looking at how you decide these cases. But what's happening is some states and their governors are just trying to push the bounds of that to the point where they want to just do away with the woman's rights. And that's where the Supreme Court's supposed to weigh in and balance the competing interests.
And I believe, isn't it in Rhode Island that very recently, was it 2018 or 19, the state of Rhode Island codified that there was a Privacy Protection Act relative to this issue. And I'm not sure that all are subscribing to that, because they're clearly in states like Mississippi and Texas and whatnot, they have no concern about privacy. They want everyone to know that it's 6 weeks and that you've gone through, as they say, counseling and the rest. So clearly interpretation is, or your religious feeling or your political inclination is still a hotbed here.
So what Rhode Island did and other states have done is to take the opposite approach of the states that are trying to restrict a woman's right to make her own decision, and to say, we are going to take what was given as a constitutionally protected right in Roe versus Wade and codify that under our law, so that even if the Supreme Court at some point in time came back and said, no, we are retracting or limiting what Roe versus Wade stands for, the right would still be protected under Rhode Island law.
And in Massachusetts, as recently as the December of 2020, Massachusetts decided that they were going to expand the boundaries to even include a woman 16 years old would be entitled to make that decision for herself too. And of course, there's going to be some counseling involved, but they're certainly going in the other direction in terms of encompassing what a woman wants to do and making her own decisions regarding her life.
Right, and it's sort of a bit of the divide that we have in our country as to different states taking different approaches and people just viewing things differently. But that some states, as you've said, Massachusetts, Rhode Island, have taken the approach of protecting a woman's rights under the law as it was laid out in Roe versus Wade, and other states trying to push as much as they can to take away rights of a woman versus the viability, even beyond the viability, if there's no viability of the unborn fetus, to limit a woman's right to make her choice.
So if each state right now, depending on whether they have a conservative or a liberal, makes a decision to have some initiative, it can be undone, it can be redone, and it seems that even this half century has shown year after year that many different states, depending on whose leadership is reigning supreme or whoever's dominant, has been able to at least proffer enough support that it gets to the legislature to consider and debate. Is that a sign of the way the law should work, that this is debated and redebated as often as someone raises a question or a factor or a different facet?
You certainly should have debate and discussion and that type of thing. But if the final result is a law that is going to violate someone's constitutional right, then that law needs to be challenged, as it has been many times. And so just because a law is debated and passed doesn't mean it's constitutional. And you can think of many examples. In fact, there's some issues about voting rights and whether or not laws that are being passed that might limit somebody's ability to vote are constitutional. And certainly, take an extreme example. If it were, well, remember, we had those laws. You had to pass, they had a poll tax or to pass a test that no one was going to pass on that particular day or do certain things to register. Those laws were all unconstitutional. They were passed, they were debated, but that just because they're debated and passed doesn't make them constitutional.
And so how do you who gets to decide ultimately what's constitutional, just and only the U.S. Supreme Court?
Well, it'll work its way up. So lower courts will hear the case, they'll develop the facts, they'll apply precedent that's already been established by the Supreme Court and their interpretation of how that applies to this case. And then as it goes from the district court to the Court of Appeals, the Supreme Court may or may not decide it's something worthy that they need to weigh in on and accept it on the writ of certiorari or not.
What do you think the impact of this is? So everyone is weighing in on it one way or another. What do you think the impact is of the fact that the Supreme Court has decided, agreed to hear it?
I think it remains to be seen. Apparently, we'll know a year from now, give or take.
2022.
Yep.
They said, I think it was, they were going to start to hear it in October, and the decision would be made in 2022. And I suppose a good cynic might say, that's going to be in the middle of the midterm election, and that will be a very hotly contested issue. It's apparently going to be on the agenda of every single state when it comes to their midterm elections.
Well, that's the problem. But the good thing is, if it works the way it should work, the Supreme Court should decide it on the law and not on the politics. And I can almost guarantee you that's what will happen.
Sounds good. And there's something that's called the trigger ban. I'm not sure that it is a state's decision to do this. The initiative is that the minute the U.S. Supreme Court decides to roll back any part of Roe v. Wade, that automatically will trigger whatever they have in their queue in terms of a ban. 6 weeks here, 15 weeks there, an abortion clinic closing, a civil right to, or that you have to report it. What does that actually mean if there are so many states now signing on to this trigger ban initiative?
So
they're just shutting it down. They're just shutting down the entire process. We won't have any more debate. The minute the U.S. Supreme Court changes any facet of this, it automatically triggers whatever was on their proposed legislation.
So if you pass a law that says if the Supreme Court does this, that, or the other thing, and then this becomes effective, it's not a really good way to legislate, because you need to know the precise logic and reasoning and what's in the decision before you have a law that says, oh, we're automatically going to be in effect because the Supreme Court said it's okay. Did the Supreme Court really say that? What did the decision say? So I believe that if there's a law that says we're going to take effect upon Roe versus Wade being overturned, if that's what it says, give or take, that's going to just leave that law ripe for a challenge too, because does it follow what that new law says?
And if they're debating the intent at one level and the Supreme Court level, I can't imagine that if someone blatantly says it's just a trigger ban, it's if this, then that.
Right.
I would think that that would just continue to have more challenges, just as you're saying. Why wouldn't they do that? And why would someone even propose such legislation at the state level? Because you would just assume that that would trigger a challenge endlessly.
How about wait to see what the decision is, see how the law is applied, and then craft a law that follows that.
And wouldn't that make more sense? So at the state level, when we hear that the Supreme Court is going to hear this case, between now and September or October when they actually hear that, we hear already that both sides are being energized to do more. Is that going to have any effect right now, the fact that you have energized more protests, more letters to the editor? Do those really affect, would you say, when it comes to the legislators who have to make a decision? Is it worthwhile for them to mount these campaigns when it hasn't even been heard what the case is going to entail?
Yeah, so that's outside of the bounds of the
law
law for
matters.
me to really tell you, because I don't know what the politics of it is. I don't know what the fundraising effect of it is, because I'm sure it affects fundraising for people who are pro-choice or who are on the other side of that equation. So I can't tell you, do the pro-life folks make more money because this decision is pending? I can only comment on whether and how they approach the analysis of the law and the politics of it. I don't know.
And what about for a doctor? In many of these cases, they're putting a challenge to a doctor that you have to do everything you can, never mind to save the mother's life, save that fetus. It's life, it's not life, it's life outside the womb, it's been aborted, but then you need to do what you can to save that unborn. Where does that leave the legal choices of a doctor in these situations?
Yeah, it's difficult, and I would think that a doctor might want to consult with a lawyer and ask, does this law apply? Is it constitutional? Do I follow it? What do I have to do to make sure I'm following the mandates of it, if I have to follow the mandates of it?
And what does a doctor do when, in fact, he may have the choice of saying, I have to make the choice on behalf of the mother's health? Couldn't he certainly skirt that and say that mother's health could be in jeopardy if this doesn't happen? And couldn't he have, I don't want to say carte blanche, but certainly couldn't he have a wider area to make a decision without really being held accountable? Do you think that's likely to happen as they raise these challenges?
I think that and again, I don't know, we're talking hypothetically because we don't have a law in front of us. We're trying to analyze and say, is it constitutional? Does it warrant being challenged, or does the doctor just follow it because that's what the law says he has to do? And what does it say he has to do? But I would say that any doctor who's making a legitimate medical decision that he can support, and the law allows him to do that, it will be okay.
Sounds right. That's his legal issue too.
Yeah.
Well, I'm sure that in the next months we're going to be hearing and reading more about these cases that are being raised in various states. Please stay tuned to The Law Matters. As we say, it matters to you.